Hello, everybody, and welcome again to another episode of the Risk Matrix with James Junkin.
Roll Tide, baby. Roll Tide. ASSP 2025 right around the corner.
And myself, Dr. Martin. And we're here to talk about all things risk inside the Risk Matrix. As everybody knows, we're powered by Veriforce. And just as the conference comes up, that ASSP conference that James just talked about, they are our sponsor, not ASSP, but Veriforce's booth. You want to give them a little jingle there, James?
Absolutely. Contractor safety done. Come see us at booth 1201, baby. And a lot of things going to be happening at booth 1201. Bunch of people that from Veriforce will be there as far as the sales staff, support staff. I'm super excited about members of our strategic advisory board that'll be there. Dr. David Daniels will be there doing the book signing. Stephen OJ will be there signing his book. I will be there. I do not have a book. I've read a few books.
But he'll be shaking hands and kissing babies for
absolutely,
sure.
Absolutely. So stop by 1201 and see us all.
So here we are with episode 103, James. We're in the hundreds now. Today we picked a topic that came up on LinkedIn. I wasn't even aware of all these things that were going on, but a topic that was brought up by John Doney, who used to be with NSC, but now is with What Works Institute. He started his own concern. It's very popular. He's doing some great things, some research-based items, but he brought up in one of his posts, you want to just give a little short synopsis, James?
Yes. I found this post very interesting because, like most people, OSHA regulations do not change very often. And when there are changes to OSHA regulations, usually there are years and years and years of conversation about it. I remember when GHS came out, there was a tremendous amount of outreach by OSHA regarding, what was to be expected, a great period of public comment. It was sort of, you get prepared for it. So I don't routinely sit around and read the Federal Register. I sort of depend upon OSHA takes and their outreach efforts, LinkedIn, discussions in the community about what's happening. And that was what my experience was when they changed the silica standard. But OSHA, the federal courts, and the Register, according to this post, again by John Doney, a lot of things potentially could be happening very soon related to changes in regulations. Bunch of them related to chemicals, butadiene, carcinogens, acrylamide nitrile.
Acrylite.
Yeah, there you go. Asbestos, benzene, cadmium, coke oven emissions. Here's one that affects a lot of people. Illumination under the construction standard, cotton dust, ethylene oxide, formaldehyde, falls under the marine standards in marine terminals, inorganic arsenic, lead, methylene chloride, methylene dialylene, COVID-19.
I think you should just leave the chemicals alone, James.
Yeah, we should let you do the chemicals. But here's some ones: record keeping requirements, general duty clause, a lot more that's on there on this post. Safety color coding, respirator medical evaluations that affects a lot of people, and some changes in the construction standards. So you can find the complete list that I completely butchered because I'm from Alabama, Roll Tide, and not an industrial hygienist. But there are some things that may affect us all when it comes to these proposed changes in the Federal Register.
So let me just say, you can go right to the Federal Register online and you can look these up. I typed in OSHA just because it's easier to kind of get them to narrow it down. But all of these on the list of John Doney's post were made on July 1st. So you'll be able to see July 1st. There's a whole running list of things, and it actually talks about each of the proposed changes or omissions or striking things. So you can go right there and you can take a look. But James, we cherry picked a few off the list because we thought they were kind of interesting. You want to throw me one?
I mean, the ones that dealt with chemicals primarily, it looks like OSHA is proposing to give some flexibility in respirator selection when it comes to things like moving from supplied air or PAPRs to half mask.
Or full face to half
or
mask, because a
full
lot of the
face to half
regulations
mask.
say you must use a full face respirator,
Absolutely.
right?
Absolutely. So I think that sort of sums up what we're seeing there amongst the chemicals. The construction illumination one I found very, very interesting.
Right. So that one basically, as far as I can tell, deals with most construction site, well, all construction sites are mandated to have natural or artificial illumination in like storage areas, aisles, hallways, places where there's work ongoing, to have that illumination in place. This proposed change is to eliminate that requirement, because it's essentially, it says that there's no lesser risk without
Right.
the illumination with the illumination. So that's a really interesting one. And I think maybe, if I can opine on this, I think maybe some of uh, the reason that this might have come up is the illumination is going to be there during work anyways. And a lot of times that illumination at night is where we see the mandated
So many looms.
Man,
Yeah.
yeah, looms at night, especially when you're under construction and when people aren't there. And I think that maybe is more under the um, illuminating to prevent hazards to people who shouldn't be on the site, or shouldn't be, right, not the workers, but people coming onto a site, and maybe that's more of a civil tort type thing rather than an OSHA type thing. Does that make sense?
Makes sense to me. Record keeping requirements. I didn't even know OSHA was considering this. Tells you how well I keep up. Evidently, there was a proposal by OSHA to add a column on the OSHA 300 logs related to tracking of musculoskeletal disorders, MSDs, in the workplace. That proposal seems to be, OSHA seems to be wanting to withdraw that proposal and axe that requirement for including that on your OSHA 300 logs as a separate item. Now, not to be confused, I don't think OSHA is saying if
don't record MSDs,
don't record it, there just won't be an extra tracking of that.
Right.
They rolled that out about as successful as they rolled out electronic submissions. That I still deal with companies that don't understand the rules related to electronic reporting to OSHA of your 300 logs.
Right. I guess I'm surprised that's not on the list, the rolling back of that, but we don't want to get into why that would be repealed. But yeah, that was something that kind of was quietly rolled in, and a lot of people still aren't doing and don't understand. And by the way, are being cited on it. I've had clients be cited on not having their electronic submissions in by
the client didn't have injuries at all, but had more than 250 employees or in a targeted industry that they consider to be high risk. You must submit your OSHA 300 logs electronically. And what we found was, even though this company did not have any injuries at all, a zero, because they did not report it, it was a $2,500 other than serious citation. Now, that was under the previous administration. Don't know if that's a point of emphasis under this administration, but there is some history there for citing for failure to submit. Another one I found super interesting, and we'll spend some time talking about this. Under the Respiratory Protection Standard 1910-134, which is the respiratory protection standard for all standards, incorporated by reference in all standards, 1910-134. Right now, there is a medical evaluation requirement prior to a worker being issued a respirator, right? And there's an appendix. It's a big form. You got to send it to a licensed healthcare provider. They got to fill it out in order to release workers to wear respirators. Shockingly, this seems to be something OSHA is thinking about removing from the respiratory protection standard altogether.
Right. In what I read, James, they seem to mention that having those medical evaluations have not shown any indication that they prevent medical emergencies or medical conditions as a result of not having them or having them. And so that's the reason that they're thinking about taking these out. Now that's a major change in my
That's a
mind, right?
huge change. Huge
Um,
change. I know over the years, a lot, I've seen it done several different ways. I think the intent was that someone was going to go to a doctor and be cleared to wear a respirator. And as someone that's worn respirators a lot, I found that supplied air for me is easier to wear. It's drier, it's not comfortable, but it doesn't put as much task on the body as a cartridge or filter respirator when you're working in with particulates, you know. Um, I think that was their intent. But what has happened is you've seen a rise of these online medical screening organizations where you just answer the questionnaire, you send it to them, they sign off and send it back. So I would say probably based on current practice, I'd agree with OSHA to the extent that maybe it wasn't being implemented the way it was designed to
it
be
was
implemented.
intended, right?
Yeah.
I mean, all I can say is, I worked in hazardous waste for many, many years and did have the medical evaluations along with the pulmonary function tests, right? Regardless, most of the companies that I worked for in hazardous waste, you had both regardless, right? There wasn't a just fill out the form and you might not have to do the PFT. Um, I passed the PFT, was cleared to use a full face respirator, right, medically,
Mm-hmm.
but couldn't use one because I was claustrophobic. So I thought you'd like that little nugget of wisdom, right? As soon as I put that full face respirator on, I started to hyperventilate. I
I
just
can
I
see
couldn't
that.
couldn't do it, right? So right or wrong, this is one thing that they're taking out. And if you couple it with the changes in having latitude in picking respirators instead of having mandated full face respirators for all of those chemicals, I think there's a clear path here that OSHA's starting to look at some of the NIOSH things that were put in place um, back in the day and that have been worked on through the years up until now when it comes to respiratory protection.
Well, I can see the train wreck coming. Okay. And as someone that's taught a lot of H2S classes, been around tremendous amounts of H2S, there's a group that markets a cartridge that will protect you up until 100 parts per million H2S. And I've always stood against companies buying that type of protection for their employees because you can't guarantee that in an emergency situation, all you're going to get is 100 ppm or less, right? We're not working in
Right.
a laboratory in a controlled environment. So as these modifications are being made, particularly to the respirators, I would say it's up to the respiratory protection program administrator of the company to do due diligence to make certain that whatever we're putting people in not only meets the requirements of the standard, but actually protects our workers. Now, I don't remember if we did an episode on this, but respiratory protection standard is one of those standards everyone needs to read if you're using respirators in the workplace. And when I do assessments, I sit down and it's obvious that the safety professionals have never read the standard, nor have they read their policy. Because the standard says the respiratory protection program administrator must be qualified by training or experience that is commensurate with the complexity of their program, right? Well, what does that mean? Well, certainly the expertise that you need to put somebody out there working in asbestos is not the same as the expertise that you need somebody that is just wearing an N95 dust mask, even though that's considered a respirator. And, so there's a lot of things that are put back on the respiratory protection program administrator. And what I find is many safety professionals are shocked to find out that in the assessment, they are by policy have been appointed as the respiratory protection program administrator. And you're like, I don't have any training experience. I mean, I haven't had a class yet in my academic career called respiratory protection program administrator.
Yeah.
At the collegiate level.
So let me say this, right? This may be a good thing or a bad thing that there's becomes an opportunity for companies to have more latitude in the selection of their respirators. However, that's a double-edged sword, right? Because if you're going to, as James says, if you're going to select the respirators, you better really know what you're doing when you select them, and know the volume and levels of chemicals that you may be exposed to, the mixtures of chemicals you may be exposed to, the capacities of your worker, et cetera. With all these things removed, there's going to be more of an onus on that respiratory protection administrator and on companies to prove that they did the right thing, right? You may be able to put somebody in a half-face respirator. That doesn't mean you should.
Absolutely. Absolutely. And, there are other hazards you may be protecting from that may, even though the respiratory hazards may be taken care of with a half mask, I always like that protection in my face that a full face respirator offers sometimes.
And be careful what you wish for. I guess that's my cautionary tale on this one.
The one that is going to generate a tremendous amount of conversation is the proposed modification to the general duty clause. So this goes back to a court case, and I think you've done some research on this, but this case went all the way to the Supreme Court related to a 2010 case involving SeaWorld. So you want to talk a little bit about that and Judge Kavanaugh's dissent?
Well, so the gist of this is, right, the general duty clause is used when there really isn't a specific standard to be cited, but there was a recognized hazard, correct? And in this SeaWorld incident where there was a fatality, right, there was no standard for the hazards that these trainers had faced, but the general duty clause was applied. And there was a dissent by Judge Kavanaugh saying that there are workplaces in which the risks are there, they cannot be avoided, and they're assumed, right? And so that the general duty clause really should not be applied in those cases. Well, it looks like this proposed change is to allow for people in the entertainment industry or those types of professional industries in which the risks are there and can't be avoided, that the general duty clause can't or would not be able to be used, right? Now, I did a post on this on LinkedIn today, and I already had an entertainment industry person comment and say, because we lack the specific standards, this is something that people in their workplaces rely upon, that they will be protected because there is this catch-all. So I don't know how you feel about that, or if you want to just give a few thoughts.
Well, the first thing I want to say is this is limited to professional, athletic, or entertainment occupations where the activities are inherently risky. Okay? So where OSHA speaks in a standard, it's still the law. Okay? This is these areas where they don't speak or there's exemptions from, right?
Right.
I'm anxious to see what actually comes out of this. This has the potential to have a lot of confusion but you're still responsible for protecting your workers. But I look at it this way: if I'm hired to swim with sharks and I get bit by a shark, you know, it's not necessarily an OSHA violation because I'm engaging in an inherently risky activity. If I'm a skydiver, right, I jump out of the plane. I don't think OSHA should be able to cite me for failure to have fall protection. Okay, doesn't make sense.
That's
right?
a little bit of a stretch there, but okay.
But in these particular instances, just remember, just because OSHA cannot cite you doesn't mean that you're not negligent or grossly negligent under a civil tort claim. Okay, so you still got to protect your worker. You still have to protect your worker. And I know many area directors really do not like citing under the general duty clause because the defense automatically is what? You don't have a standard, right? You don't have a standard.
Then the burden of proof is prove the hazard.
Prove the hazard. Recognized. What does recognized mean? And it opens it up for a lot of debate. So in my magic world of James, when I'm benevolent dictator, soon, I'm gonna run. I appreciate everybody's vote. Right?
Do you run for benevolent dictator, or you just take over?
Well, I think you got to run. You got to run.
Okay.
It's the American way, right?
Okay. Then once you're in, then you're the benevolent dictator, and there's
that's
no
right.
more
I'm the benevolent dictator at that point, and my campaign slogan is "Some stuff's going to change." Right? Some stuff's going to change. I wish government agencies would speak in regulatory language that is plain. Okay? Like, what does recognized hazards mean? Just saying. I think OSHA could be a little more specific sometimes in the language that it uses. But when you start using language like that, it's open for interpretation. And in a civil case, that's going to be a jury question. Existing and predictable hazards, right? So I think it could tighten up a little bit of language someplace. But remember, you're responsible for the safety of your workers. I'm certainly not advocating any safety professional go out there and try to find a loophole. Here's the loophole. And I'll say this about my opinions of OSHA regulations sometimes. OSHA regulations are not written by the great safety professionals in Washington, D.C. They're written by lawyers, lobbyists, and the government. Okay, I think that's something we can all agree on. There's nothing more screwed up than lawyers, lobbyists, and the government, right? They're not the experts on safety. Right. That's why you get differences between the construction standard and the general industry standard. Like, all right, the number one cause of death historically in the construction standard's what?
Falls.
Falls, right? But the general industry standard's at 4 feet, construction's at 6 feet, with
scaffolds
exemptions up to 15 feet for iron workers. And guess what the number one cause of death for iron workers is?
Falls.
Falls. So I understand. Look, it's what you can get past. And there are a lot of exemptions. For example, are you aware that the upstream oil and gas industry is exempt from the lockout tagout standard? Do you know that?
That a lot of people don't.
But there's not an oil and gas operator out there that lets you operate without energy isolation programs, et cetera. Because not only OSHA might not be able to cite you, but it's definitely an industry best practice. It's something you see,
and it's protective of your workers,
and you still got to protect your workers. So moving beyond the loopholes of what you can find, you may or may not be able to be cited, but you're still responsible for protecting your workers.
Yeah. So the takeaway in all this, right, for me was when I saw Mr. Doney's post, I thought, oh my gosh, this is something that I wasn't even aware of. Now, granted, it's only been out a little over a week that all these things are posted on the Federal Register, but these are a lot of changes and they affect a lot of different industries, especially where the chemicals are involved, right? And it seems like they're targeting a lot of respiratory protection stuff, which a lot of industries have to have programs and policies in place for this. So the takeaway for me is make sure that you're keeping track of these things, right? Go to the Federal Register every now and again. Make sure you're going to the OSHA webpage. Every once in a while, I just go to Google and search OSHA news and see what's coming out on OSHA. So it behooves us to stay current in our practice in a bunch of different ways, but especially when it comes to regulations that are coming in the pipeline that might be struck down, made more stringent, or made less stringent.
Well, I agree 1,000,000%. Like I said in the past, things just don't change that much. But these are proposals, and there'll be a public comment period. Get on the Federal Registry. If you've got something to say about this, you think they're proposals or something that's outstanding and you want to weigh in on that, hey, go ahead. If you're on the other side of this and you want your voice to be heard and say, hey, but you're not thinking about X, Y, and Z, now's the time to do it, because once it becomes part of the standard, it doesn't matter what James or Dr. Martin or anybody else thinks. Guess what it is? It's the law.
You're going to do it. That's right.
We're going to do it. We're going to do it. So it's just interesting that a lot of these came at one time. So some of them,
it'll be interesting to watch, and maybe we can have another show once some of them start to kind of get more into the rulemaking process.
Well, I think a lot of this, OSHA says it's proposing to eliminate dozens of regulatory requirements that it says are outdated, duplicative, or improperly inflexible. Okay. Some of this is because we're trying to update things that are outdated. Others of this are directly related to, I think, the implications of what happened in the Chevron ruling, or striking down Chevron. And we'll see what governmental agencies' authorities are and what congressional authorities are as we go through the Roberts Court.
Yep.
Like, I'm super interested in what's going to happen with the multi-employer citation policy.
Yeah, that'll be interesting. So that's it again for another episode of the Risk Matrix, James. Thank you guys for tuning in to us every single week. We really appreciate it. We do this for you. I know James says that all the time, but we do this for you. We want to bring you topics that you're interested in. If you have something that we haven't talked about and you want to hear, hit us up, let us know. Join us in the LinkedIn conversation. James and I are both on LinkedIn and putting stuff out there all the time. We welcome your comments. We welcome your criticisms, and we hope you keep listening.
Absolutely. Absolutely. Very passionate. We put a lot of thought and effort into what the topics are for these podcasts. We hope they're valuable to you. If there's something you want to talk about, let us know. If you're super passionate about it and you want to articulate it, hey, we'll have you on as a guest. And we don't always have to agree. It's okay to disagree sometimes, right?
We do all the time. Anyway,
I hope I will see some of you at the ASSP 2025 conference coming up in Orlando. Until next time, y'all keep bringing those workers home safe from high hazard jobs, and roll tide, baby.
Roll tide.
Roll tide.
Are you planning to attend ASSP Safety 2025 in Orlando this July? We'll be there July 22nd to 24th at Booth 1201. Stop by to connect with industry experts and explore smarter solutions for contractor management, compliance, and training. Don't miss James Junkin and our expert speakers tackling hot topics like procurement versus safety. Let's build safer workplaces together.